Hello friends, in the series on the income tax cases, today I will discuss the case of Principal Commissioner of Income Tax versus Nestle India Limited. This case has been reported in 457 ITR at page number 216. The matter has been decided by Delhi High Court and the date of the judgment is 4th July 2023. This case is related to the assessment year 2009-10. In this case, there were two very important pertinent issues. The first issue was regarding the applicability of the depreciation rate of enhanced rate of 60% which is applicable on computers. Although this rate has been revised in the present scenario, but for the assessment year 2009-10, the depreciation rate was 60%. So the question was that whether this 60% rate will be applicable for the UPS, which is necessary for keeping the continuous supply to the computer in case of when there is power failure, and to secure the data in case the power is not available. It was the submission or it was the contention of the assessing officer that the UPS can be used for another purposes also. So the higher rate of depreciation should not be allowed to the assessee. When this matter came for the higher appellate authorities, they were of the view that the assessing officer was not able to prove that UPS was used for any other purposes. So the rate of depreciation, which is 60% on computers, should be also given to the assessee on the UPS. Although the ITAT said that every instrument which is there for the uninterrupted power supply to the computers cannot be said that the depreciation of 60% will be there for that. For example, if the UPS is there, then it is directly related to the computer. But if the assessee wants that there are some other instruments, like the assessee has made some electricity connections and good wires, and if the assessee wants to claim the depreciation of 60%, then those will not be applicable for 60% depreciation. But the UPS, which is directly related to the computer, will be eligible for 60% depreciation. The second point was that in this case, the assessee received a subsidy of rupees 25 lakhs from the government of Goa for setting up an industrial undertaking in a backward area, which was for giving the employment to the people, and this subsidy was to be given at the rate of 25% of the total fixed capital cost of the assessee. The assessee treated this subsidy as a capital receipt, which the assessing officer disallowed. When the matter came to the CIT appeal admitted that this is a capital receipt, but at the same time, the CIT appeal reduced the cost of the fixed assets proportionately. It was the point of the CIT appeal that this subsidy has been received towards fixed cost, towards fixed capital cost. When this matter came to the ITAT said that the purpose of calculating the subsidy cannot be treated as it is for that purpose. For example, in this case, the method of calculating the subsidy was 25% of the total fixed cost. So the methodology of calculating the subsidy cannot be taken as it is for that purpose. In this case, the assessee has to receive the subsidy of 25% of the fixed capital cost. So it cannot be termed that it is received for the fixed assets. So if the CIT appeal reduces the cost of the fixed assets proportionately and then allow the depreciation, then it is not a correct way of interpreting the law. So the ITAT allowed the full cost of the fixed assets for depreciation. When these two matters, for the UPS depreciation at the rate of 60% and the point of depreciation on the fixed assets after considering the subsidy, when these two matters went to the Delhi High Court, the Delhi High Court also upheld the order of the ITAT. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Nestle India Limited. And this case has been reported in 457 ITR at page number 216. The matter has been decided by Delhi High Court and the date of the judgment is 4th July 2023. Thank you, friends.